Good morning, Carmen. Good morning, Oscar. Thank you for joining us this morning on the follow-up conversation from the employment law updates that you led for us, Oscar, in January. And thank you, everyone who's joining us on Zoom and joining us live on Facebook or in LinkedIn. If you have any questions, please drop them in on the messages, or on the chat for Zoom. This conversation is intended to follow up on the employment laws that are taking effect in 2023. The employment law updates is something that we have been creating on an annual basis. And Oscar, you've been leading it for probably a good 8-9 years, probably. So, and one of the things that I notice is that the employment law updates come in. Everybody gets the updates, or those participants get the updates, but then there's the question of how you implement them. What do you do with them? Some employment law updates are very simple and straightforward, and somebody can just move ahead and run and make the changes. And there are certain laws and changes that do require a deeper conversation. And with us today is Carmen. Carmen, you're a human resource specialist and founder of My HR Specialist. And you deal with, how to implement this. You're on the ground, you're working with employers, you're working with HR managers, you're working with team members. You're basically taking these laws and bringing them to life inside of an organization. And Oscar, from your side, you have an understanding of what the employment laws are, what's coming, and you understand it from a legal standpoint. So today we want to touch on those laws for 2023 that organizations, managers, employers, should be thinking about and paying particular attention on how they bring it into their employee handbooks and how they bring it into the workforce. And I'll start off with the new one, the new law, Oscar, that you mentioned in the updates, which is leave of absence for bereavement. And from what I understood and gathered, that was not a law or a requirement that was there in the past. And it's something completely new that organizations are going to need to embrace and work with.
Yes, that's a brand new law creating essentially a brand new right. A lot of times every year the legislature passes a bunch of laws throughout the year, but basically they get signed sometime in October. And they start getting published. A lot of them either go into effect the first of the year, or sometimes they get pushed 1 year later. But yes, this is a new right. Any employer who has 5 employees, who employs 5 employees, will be required to give. A lot of employers had policies sometimes that would grant bereavement leave, but because it wasn't required, they could create 2 days, 3 days, 4 days. This one requires 5 days, and there are some ambiguities in the laws, but at this point, this is something that it would create essentially a new entry in an employee handbook, where the employer would indicate that the employee has a right to do it, to take this leave, and what are the requirements, because there are some requirements that it has to be taken within 6 months of the death. The employer can request certain information, but this is a brand new right that California has implemented.
What is the time frame that's allowed, required, or at minimum that an employer is required to provide?
It's 5 days, which can be broken up. So you could take 2 days and 3 days, or vice versa, or break it up in any way you want. And if I recall correctly, I haven't seen the presentation in a while, but I think it has to be taken within 6 months of the death. And it's the way it reads, it says basically that you're entitled to 5 days per family death. If there's an ambiguity there, whether what if you lose 2 family members in an accident? Is that considered 2 deaths or 1 death in 1 event? But the way it reads right now, you could make the argument that you would then be entitled to 10 days. And it's per death. So if in a year you really have a really, crappy year, and you have multiple deaths, you could create, could get more days. So it is unclear how that is going to be interpreted by the courts, but my sense is that in one event, it'd probably be 5 days, but if it's 2 deaths at different times of the year, you probably will get more days.
Are these paydays or are they non-paid?
These are non-paid. The only paid day that you get is called under the paid sick leave act that was passed about 3 or 4 years ago. Under the state, you get 3 days. If you live in LA, you get 6 days. And if you live in different cities, you get different days. In the Bay Area, you have a lot of progressive governments that have extended that amount of time. But I think you can use that time, and you can also probably use vacation time during that leave. So you could get paid that way. But if you don't have any of those, the leave is unpaid.
And one of the thoughts or questions that comes, Carmen, from an implementation end, there's PTO, there's pay time, there's sick time, there's vacation time. How does an employer bring this into, how do they take this new guideline or law and put it into effect? And does it go towards PTO? Does it get treated separately? And is it just as simple as updating the employee handbook, or is there something that you need to bring into have a conversation with the team members? What's the best approach to being able to embrace this type of change that hasn't really existed before?
Well, definitely a lot to do, and one of the best ways to make the change is yes, to your policies and your handbook. And if you just recently updated your handbook and you realize that you haven't made an entry such as this one, then what I would recommend is just adding adding another page or a note to the handbook stating, like an addendum, right, stating that this particular policy has changed, and make sure you distribute it to your team as well, and that they have acknowledged receipt of it by signing for it. So you want them to sign that they've received that again. And then the next time you come around to updating your handbook, make sure you add it fully in there so that your handbook remains as up to date as possible. In terms of the implementation piece of it and how do you process or use vacation time, sick time, the recommendation is, that something like this, if you have PTO, which PTO really is the combination of your vacation and sick time into one policy, as long as it meets the required guidelines for the city of Los Angeles or California, just the way Oscar was mentioning, then you can have a PTO policy. If you have a PTO policy, then you can let your employees know that if the bereavement leave is unpaid for your company, then they may apply PTO towards that time off. And what I'm also finding is that because previously most employers have been practicing the 3 days of bereavement leave, which again was something that they could do, they didn't have to have it. And so, but if they were already offering it as paid time off, and now that they have to offer 5 days, what I'm noticing with some employers is what they're doing is that they're continuing to offer the 3 days paid and 2 days unpaid. And that is also okay, to be able to do that. And so that's definitely something that's helpful. Some employers, are able to be a little bit more generous and do the 5 paid days. And then there are some employers who, unfortunately have to maintain that unpaid time off. But the value here is in just knowing that the employee can take time off for bereavement without, penalties, without any, things on their attendance records, and it can't be used against you. So that's one of the differences that employers are recognizing.
Is there any difference of how it gets implemented between full-time and part-time employees?
And Oscar, maybe jump in on this too, but from my perspective, what I'm seeing is that, look, whatever you offer to your, something like this. I haven't seen anything specifically that says, that only full-time employees are eligible. So, I do believe that everybody's eligible for this leave. So if someone works a regular, 8-hour workday on a Monday, for example, then 8 hours is what you would pay. If someone's part-time and they typically work 6 hours, then 6 hours is, what you would apply towards that particular day. And Oscar, please jump in, if there's anything you want to add to that.
I mean, the only requirement in the statute is that you have 5 employees, which qualifies you as the employer that's covered. And then the employee has to work 30 days. After 30 days, basically, they have the right. If somebody's working part-time, I think Carmen is correct. Basically the time that you give them is the equivalent of one of their days. So if somebody works 4 hours and they get 4 hours, but basically that's their day. There might be issues in terms of somebody who works a varying degree of hours. So one day you work 4, the next one 6, the next one 8, and you go back to 3. I don't think the statute itself has a way of doing it doesn't provide any guidance as to what it should be done, but it basically does. What it basically says is basically you go back and look at, I believe it's either 90 days or 30 days of actual work hours, and then you average it out. So you add all the hours in 30 days and you divide it by 30. And that gives you an average. And you basically, each day is that average. I assume that under the circumstances, using that system would probably work. I don't think the statute provides for that, but I think that that would be kind of an equitable way of doing it. You don't overburden the employer by requiring more hours than they should. And you're pretty fair to the employee. And I think if you use that method, you should be okay. My sense is that the labor commissioner would probably come out with some sort of regulation that deals with that issue, but they'll probably use a method like that.
Yeah, and as until that method comes out, until the Labor Commission, comes out with something like that, the other method that can be utilized is, if you typically provide a schedule, 1 month in advance, or, whatever that regular schedule is. If every Tuesday, for the last 6 months, somebody's been working 6 hours, but on Wednesdays they work, 4 hours, then if that's the typical schedule, that's the common schedule, go based on your typical practices. And again, you can't go wrong when you are following practices, that, are familiar to everyone.
One of the thoughts that, when we created this conversation is looking at, looking into the future is organizations that develop best practices are going to have an advantage over managing the cost of insurance, employment practices being one of them. Do these kind of, updates or changes, if an employer is not following them, does it create an exposure? Are there penalties that they would be exposed to from the state? Will this increase the likeliness of employment practices liability exposure for an organization if they're not embracing or keeping up to date with these sort of changes?
Absolutely. The way I envision always the presentations on the law is that the new laws come out and they have to be then transferred into some sort of usable knowledge for the agency, and generally that is through the work, the employee handbook. That process brings it into the organization, and then you shouldn't just forget your employee handbook at that point. If that's all you're doing, then you kind of are burning money for no reason. The employee handbook should be something that stays updated, and every year the agency should, or the employer should, not only know what's in there, but what's being changed and implement those changes. But also in a bigger agency, make sure that your supervisors know about it, so that that information gets trickled all the way down. And that will diminish your exposure to somebody making a mistake. So for example, let's say that, as Carmen says, an employer had a 3-day bereavement leave. And somebody says, look, next week I have a relative that died in New York, and I need a week. And the guy says, no, we're super busy, and you're only entitled to 3. That's our leave. And the person takes off and they get fired. because their policy wasn't updated. Well, now you have a wrongful termination claim, and that will then trickle into, now you have a reported claim, and that'll impact your rates. So this whole process of making sure you're up to date and making sure the employee handbook is up to date and making sure your people are trained on what the laws are, it's a way for you to essentially protect your interests. It's essentially should be viewed as a risk management. You're managing a potential risk. And even with insurance, there is a deductible you're going to pay there. If there's a claim, you're going to pay that deductible. Generally, the deductible is going to be gone. But after that, there are some things that are not covered. So, for example, punitive damages are not covered by policies. If it covers wage and hour stuff, generally wage and hour claims are not covered. You may get coverage for defense costs, but not for the indemnity part. And so all of these things are ways for you to manage potential risks in the future. And then on top of that, if you get a lawsuit, you also get a big disruption. There is discovery, there's going to court. If you hire me, I'm going to be calling you for information almost as soon as you retain me, because I need to know what happened so that I can evaluate the case and, devise some sort of strategy to defend it. But all those disruptions can be very intrusive on an agency. You got to get documents. Some people may have to sit for deposition, and all these things are both expensive and very disruptive.
Yeah, and including the impact on the morale with regards to the rest of the employees who the claimant may be friends with or have relationships with. One of the things that you said is, having it trickle down to the managers. And Carmen, I'll go to you for this one, because, if you're working with an organization, if it's a small organization with 5 employees, you may have the business owner who's actively involved and, has a relationship with everyone. But as you start getting into the 20s, the 30s, the 50s, the hundreds of employees, now you have a whole leadership team, management, and different layers of managers through that. How do you bring that into alignment so that, as Oscar's saying, these changes are not just staying in an employee handbook and sort of resting there until something happens, but rather how do you bring it to life, this employee handbook, and incorporate, engage everyone at the different levels, from leaders, managers to team members?
Yeah. Well, engagement with your management team is actually one of the most critical pieces, on being able to minimize that risk of liability. And the way you do that is you do that through trainings. The trainings are so critical. Look, the bottom line is managers, supervisors, they all have, a lot of other responsibilities to be managing. And so there's no way that you're going to be able to train your team or anyone on all the laws and all the do's and don'ts. However, if you at least share a little bit about, what the losses can be or what it means when someone makes a decision without really knowing the rules and without reviewing the handbook, that at least gives them an opportunity to reconsider and to say, you know what, this is probably something I need to have HR handle, or this is something I need to, take to the next level. So what I recommend is a 1 to 2 hour training session with your management team, with your supervisory team, anyone who's able to make hiring or firing decisions, anyone who, manages performance for any team member. Definitely engage them, have them understand the policies and procedures, the rules and regulations that are in your handbook. All it takes is a 1 hour session, going over the handbook and just briefing through it. You don't have to learn everything. I mean, it's tough. I think Oscar can tell you the same thing, is that even he and I'm sure we have to reference, certain things before we can respond to, all the questions that come to us. But as long as they know that there are resources available to them, they don't have to make all the decisions. One of the things that I find most is that supervisors will make decisions on the spot based on how they feel, based on, whether or not they consider an employee to be a good employee or, a trouble employee. I mean, those are not the best ways to make decisions. The best way to keep your team happy and to ensure compliance is to be fair. And fairness comes from following your policies, your guidelines, and that handbook is exactly what it is. When a team member sees you pull out a handbook, let's say they ask you, hey, you know what, I have a question about bereavement leave. The handbook says 3 days, but I heard recently that it's now 5 days. You know what? Hang on a second. Let me grab my handbook. You pull out your handbook and you open it up. And when the employee sees you really using that handbook, they know that you're making decisions, straight across the board out of fairness and not just a decision that you think is the right or the best one in that very moment.
That's a great point, because oftentimes that book or that booklet rests in a cabinet somewhere. And I think long are the days where, that used to be a practice. Now is really the necessity to embrace those handbooks. And I really love that you're both really highlighting that. When we look at employment practices liability, particularly in Los Angeles, it has doubled or tripled inside of what the cost would be for an employment practices liability. It used to be that a small organization can buy coverage for employment practice liability for $3,000, $4,000, or $5,000. Some of the renewals or the offers that we're seeing coming in, they're coming in at $12,000, $15,000 for those organizations that were paying $3,000, $4,000. And if they're in a larger organization, they're coming in more in the 30s, $50,000, $60,000 worth of cost. A big part of the driver in that cost is several factors, but one of them is coming out of the pandemic and all the claims that got created as a result of the going back and forth with employees, the downsizing or the shifting of schedules. And also some carriers have pulled out of the employment practices liability market. So there's less options inside of insurance carriers willing to extend an offer. And if you've had claims, then it adds an additional factor to your cost. And what we're also seeing is that where you would see deductibles that were $2,500 or $5,000, now the deductibles are coming in at $10,000, $15,000, $25,000. We've seen some deductibles as high as $150,000, which it's having an impact on the cost of doing business and operating and being able to purchase and maintain this coverage. So what you're bringing in inside of embracing these employee handbooks and just using them as a guideline is highly valuable. There's a couple of other updates that, on the first session in January, Oscar, you touched on, and one of them was designated person under leave of absence. Is that connected to the leave of absence for bereavement, or is it its own law?
They haven't yet, but my sense is that it will be. So this is a new law that amends actually two statutes. It amends the California Family Rights Act. So when people say, I'm taking FMLA leave, California had a law that is very similar to the FMLA, which is a federal statute. It gives you 12 weeks of leave time. California statute is called the California Family Rights Act, and it gives you 12 weeks of leave, either because of your own illness, you need to take some time off, or the illness of a family member. And up to recently, the definition of what encompasses a family member was pretty clear. It's a spouse, grandparent, parent. I think it covers some in-laws, but it was, son, daughter, adoptive, or natural. It was very clearly defined, but it left a big gap in people who were living together who might have essentially the equivalent, the functional equivalent of a spouse, but because they weren't married, they weren't a spouse, they weren't related, so they didn't fit within this definition. So this law basically allows an employee to say this person is also someone who should be considered essentially the functional equivalent of a family member, and so I could take time off. So now the California Family Rights Act says, if somebody designates someone, you'll be entitled to those rights. It also amends the paid sick leave, which is the state statute that says you get 3 days of paid sick leave. this is the one where, if you work 30 hours, you get 1 hour of leave. It has been extended in the LA city, extended it to 6 days a year. But basically it amends the state statute saying that you now have that designated person also be a qualifying person for you to be able to take the time off. So now you can actually say, Carlos, my living girlfriend is sick and I need to take some time off. Now you're required to give me that time off, and also I'm protected by you either taking some sort of retaliatory action or something like that. So this new law expands a little bit that definition, but it does it for both statutes. And it's a big one because, a lot of people who are probably not married would now have that protection, but it's not limited to just someone who is the functional equivalent of a spouse. It basically opens it to almost anyone. The definitions kind of say that, it should be someone that has kind of the functional equivalent of a family member, but it's so broad that it could be a neighbor, it could be someone you care, you provide care for, or someone you just have that attachment to, who, blood-wise you have absolutely no connection, but if you have that emotional connection, it will qualify. So it gives you basically kind of that one designation. You can do it once a year, and the person can do it basically at the time that they require. They can do it in advance, but they can actually do it on the day that they're asking for the leave. So yeah, that's a kind of an expansion of it's an extension of a right, but it actually is a very important one. And this will require, some sort of amendments to obviously those two policies, but in the future it may be extended further. So yeah.
And this brings me back to you, Carmen, is how does that get included or embraced within a company culture? How does it become part, another addition or addendum to the employee handbook? And how do you embrace it as an organization and employer?
Yes, definitely. It would be part of the addendum, and when especially when that there will be, 3, 4, 5 changes in the upcoming year, you can create a one-page addendum. Typically, a one-page addendum would work, and you can insert that, you provide it to your team. But again, the most critical piece of this is that you update your management team, that supervisory team. The person who receives the text message in the morning, I'm going to be late, or I need to call out sick for this reason. And if they have previously known for, 5 years that, that sick time is for family members, and now they're calling you and telling you, my neighbor needs my support, or, whoever it might be, and they say no, again, that can get you into the kind of trouble that you don't want to be in, just because you weren't aware of a specific change in wording. So the change in wording is very critical. Your handbook should definitely be updated with that. Look into, is it just a designated person that I have to add, or is there other wording that needs to be modified as well to fit that? Not only that, but then look throughout your entire handbook, because where else have you referenced a family member? And like Oscar was saying earlier, is that right now bereavement leave doesn't say designated person, it still says family member, immediate family member, right? And there is a list of what that means. And as an employer, think about, where can I be considerate, particularly with how things are going, where can I be a little bit more generous? And so if you start practicing your policies straight across all of the type of leaves, then it's going to be really easy to manage which leave, has family members only, which leave as a designated person. But if you really look at all your policies straight across the board and think about, how does it really impact you? What kind of a difference does it make? And if it's not such a big difference, could we really just implement our policy straight across the board so that designated person can fall into some of the other categories.
Thank you. Thank you for that. Medical cannabis is it's now legal. There's an employment law update, but one of the things I got from you, Oscar, is really not a big shift inside of any being much different than how alcohol was treated within the workplace. That it just wasn't acceptable. The one thing that I did know difference is that as a state, as an environment, as a culture, is now readily available in ways that were not there before. So the use of it, somebody goes on break and says, I want to smoke something. They go on their lunch break or their break. And I'm curious from your side, Carmen, and seeing if there's anything that you're noticing. But Oscar, can you just give us a short synopsis of what that entails as it relates to cannabis, medical cannabis?
Sure. It was made somewhat of a big deal, but the way you should see this law is basically treating cannabis the same way that alcohol has been treated in the workplace. In your example, where somebody goes on a break in the middle of the day, and they drink a lot and they show up drunk on the second half of the day, that's illegal. I mean, that's not proper for that employee, and the employer can actually discipline that employee. The same thing applies for cannabis. Basically, what the law does is it prohibits the employer from punishing someone who uses cannabis during their recreational time or their off time, not during the work time, and they're not showing up to work high. And the way they went about it is that the testing for cannabis was always kind of used in the old days for under kind of the zero tolerance policy. So if you had any signs of cannabis use in your system, that the employer could essentially terminate you. Unfortunately, for those for certain employees, they use cannabis over the weekend, and this test did not discriminate as to whether you were high, now or high on Sunday. And what it does is it basically limits the employer to use a test that actually tests whether you're high at this point. It doesn't prevent the employer from taking action against someone who is high at work, who is essentially a danger to themselves or others. It exempts certain industries like construction and I think transportation from the coverage of the statute. But all it's doing is it's essentially treating it like alcohol. An employer doesn't have the right to tell me if I had a few drinks on Saturday when I'm not working. The employer doesn't have the ability to punish me for that. That was in the statutes way back, but I think they're making it very explicit. I think it's a function of the changes in the law. That for the big case that we have dealt with when marijuana was basically being used for medical purposes, and the California Supreme Court basically didn't give it too much protection. I think this is going to change that, and I'm sure that a new case examined under the new statutes will probably come out a little different. But in any event, it's basically saying, you still have the right to discipline someone who comes to work high or drunk. If you can't really punish someone for having done it a while ago. And if you're going to test someone for cannabis, the test has to be something that actually tests for somebody being high at this point, as opposed to just signs that you were high within the last 2 weeks.
Are you seeing any of these changes and adjustments out there in organizations, Carmen, or issues arising from the use of cannabis?
I think, it's always been a concern because, just like with alcohol, being under the influence while at work, particularly if you handle machinery, you're a driver, or, you are having to use a forklift to move things around, all of that can be, a safety hazard. And so employers are wondering, like, how do we make sure that everyone remains safe, when marijuana is now legal? And again, this is the difference. Is that the truth is that, it's still not okay to be under the influence while at work, particularly, while performing duties that do require you to use heavy machinery or equipment. And so with that in mind, the employer still has the right to test, when there is reasonable suspicion. And reasonable suspicion can be when that employee goes to their break or to their lunch and they come back smelling of marijuana. You know, because while, it can remain in your system from a couple of weeks ago, from, a few days ago, but the scent, gives you the idea that, okay, yes, there is reasonable suspicion that they just returned from, smoking. And so with that, then you may test. Don't send them off for testing just the way you wouldn't send someone if they had been, drinking. You don't want someone to get in their vehicle and drive, but rather you have to now take the precautionary measures to get them to the clinic safely, to have them tested, and follow your same policies. If you have any questions about that, whether you can do something or not, I mean, definitely check in, with someone like Carlos or myself, pardon me, Oscar or myself, and, you know, make sure that you are not making decisions based on what you think is the right thing in that moment. And what I am seeing though, Carlos, to answer your question of some of the changes, is that some employers are feeling like, gosh, I feel like, I can't test anymore. It's not something that I can test for anymore. And so I am seeing some changes in policies, particularly for, new employment hiring, where employers previously were testing for everything that they could. And, before the start of employment. And so now the difference is that if you are testing for drugs and alcohol, or really for drugs, is that your test, or the test that you're using, or the service that you're using, can actually differentiate between actively under the influence, in that moment, or if it's in the system. And I do know, and perhaps Oscar, you might know a little bit more detail on this, but I do believe that there are tests, that are able to provide that type of accuracy.
Yeah, and the statute actually goes into detail what they're concerned about. Apparently, when you get high, your system breaks down essentially the psychoactive thing that's in THC, which is in marijuana, and it leaves some sort of trace, and that trace actually stays with you for a while. And so if you're testing for that, that's a problem, because it doesn't pin it to a particular time. So you need to do a test where actually it shows that somebody's high at this moment. And so, for alcohol, that would be generally either a breathalyzer or some sort of blood being drawn. I assume that there are some of these tests. I don't know what they're called, but I assume that there are. In terms of drug testing, it's actually a big issue because it brings in, a lot of privacy concerns for employers. And there's different policies, and the law treats them differently because the intrusion is bigger. So, you can generally, you can have a policy that tests anyone who's being hired. You can test someone who, you can do the random testing, and random testing is actually the worst you can do. This more difficult to actually get, and generally that's not a recommended way of doing it. And also you can do essentially, as Carmen was saying, the reasonable suspicion. That's when you actually see signs of somebody being sick. And you can also do one post-accident. So they all have different requirements and different concerns, but it's essentially an analysis of your privacy rights and what kind of intrusion it is. The more you can pin specific conduct to the employee who's going to be tested, the better off you are. But if you're going to be doing anything like this, please talk to one of us or somebody else who actually knows these policies, because it triggers a lot of obligations, and different testing policies have different requirements and different risk, obviously, if you get it wrong.
Yes, and then the other thing that I'm seeing with that is that employers, have changed their pre-hiring requirements to say like, look, if we don't have positions that require the use of certain equipment or driving, and these are office roles or, administrative roles, then, we're not going to do that kind of testing, and we're just going to leave it to, suspicion testing, and just testing based on that, on reasonable suspicion. And so that's definitely something that's been working for a lot of employers, and I feel like a lot of employers shifted that a few years back, actually, when marijuana became legal in California. And as a result of that, what they were finding is that, gosh, if it's in their system for a couple of weeks and my policy says that they cannot be under the influence, and it shows up in their test, I'm going to have to terminate my entire team. What am I going to do? So I think a lot of employers definitely took that as an opportunity to modify their policies. And I think that's what we can do right now, is that you start to look at, where can we be more flexible, where can we be more cautious, where's the room for training. And so again, it's just reevaluating what you're currently doing to make sure that you can still remain compliant and still minimizing that risk of liability.
Wonderful. We're down to our last 3 minutes for today's scheduled time. So I wanted to, there's certain areas that we did not cover, including some Carmen, from sexual harassment, picking back from 2022. CalSTRS and the 401k requirements. And there's also, well, if I read correctly, we have now been declared the pandemic is over. That's what I saw, the update from the governor this week. And so there's COVID updates as well. We've been moving out of COVID, and we're now at a phase where I think where it seems that the worst is over. But any final thoughts from both of you? And we have about 3 more minutes to go.
Ladies first.
Oh, thank you. My final thoughts are really is, there's no way that employers are going to know everything that has to be done. So you have a lot of resources. There are so many resources available to you as a business owner. Reach out to those resources. Be informed, because it is so much easier and is so much less costly when you pre-plan for for the changes that can easily take place. So a lot of the policies that we've been talking about, it's really about making some changes into your handbook. You don't have to know all the details, but unfortunately, these agencies, even if you had no clue, there's no way for you to know about it. I just had a couple of clients reach out to me yesterday, letting me know about some huge penalties. And, their response was, we didn't know, we had no idea that had to be done. Can't we, get a, clearance on this? And it's like, they don't care. You're an employer, it's your responsibility to know. So be informed, stay up to date, reach out to your resources. And it just takes a little bit in the beginning. You spend a little bit in the beginning to implement your policies and procedures, and you can avoid those, really high penalties that can come from mishaps.
Thank you.
Yeah, it's pretty much similar to that. The HR function is actually a very important function that a lot of employers don't really take seriously. Or, it's always in the background, especially if it's a small business that's more concerned about, hey, how much money is coming in. But it could be something that could create some serious problems for you. I think Carmen just touched on it, but, I can't even count the times when somebody comes to you and it's the first lawsuit they had. And, the first things I'm going to ask for is I want to see the personnel file, I want to see the payroll records, and I want to see your employee handbook, because those are your first lines of defense. And from that, I'm going to get a pretty good idea whether, you have a serious problem or something that can be defended. And it might even impact, even if there is a resolution, how that resolution is going to be reached. So consider the HR function and managing your employees, as a way of protecting your interest. And the more time and the more informed you are, the better off you're going to be. You won't be caught by surprise by something like that happening. And the bigger you are, the more, I guess the risk is higher, because now you're delegating authority to other people who will be acting on your behalf, and whatever they do, it's going to impact you. So you're talking about your supervisors and managers, and if they are not trained, then you can have this problem. So the HR function is just a way for you to control and manage this risk. You can't eliminate it. It's just like, if you're going to be driving, you're exposed to an accident. It's the same thing. If you're going to be doing business in California or anywhere else, you have that potential risk. And this is a way for you to manage it. And it's a very important one. The last thing you want is to be in your office and somebody comes in and says, congratulations, here's a lawsuit for you. And then, you don't even know what you did wrong. And so this is a way of doing it, that's making sure you understand the law, making sure it's getting implemented, it flows through from HR all the way down, and then look for those protections to mitigate the risk, like policies, insurance, EPLI insurance policies, to protect yourself from those types of risks. Over time, you're going to be able to manage that risk, and you kind of are not going to be as surprised. No one can guarantee you that you won't be sued, but if you're prepared, you're going to be in a better place.
Thank you, Oscar. Thank you, Carmen, for your input, insights, knowledge, and wisdom in sharing it in these conversations. Thank you, everyone who joined. If you'd like to connect with Oscar or Carmen, you could find them on LinkedIn, Carmen Torres under My HR Specialist, and Oscar Rivas under Rivas Law. And join us on the next one. Stay in tune with us under social media, Facebook, LinkedIn, and Instagram. We'll be announcing the next conversations coming for the month of March. Have a great day, and thank you for joining us.